This video was created with AI to support SQE1 study. We are independent and have no affiliation with the SRA, Kaplan, or the SQE. We do not share exam content, and our videos are for informational purposes only and should not be used as legal advice. Please check and refer to primary legal sources and recommended prep guides as you study.
Welcome back to New to Law. All right, today we're jumping into the lower civil courts in England and Wales. I want you to think of these courts as the real engine room of the civil justice system. Honestly, understanding how they work isn't just a nice to have, it's essential. So let's dive in and make this super clear for you. Okay, here's our game plan. First, we'll get a handle on what civil law is really all about. Then, we're going to do a deep dive into the county court and its different tracks. After that, we'll look at the magistrate's court and its surprisingly specific civil role. Then, we'll map out the appeal routes, super important for the exam. And of course, we'll test your knowledge before we wrap things up with the key takeaways and those common pitfalls you want to avoid. At its heart, civil law is all about sorting out disputes between people or businesses. Things like contract disagreements, issues between landlords and tenants, or personal injury claims. For your SQE, being able to spot the difference between these civil matters and criminal cases right from the get-go, that's a crucial skill. And this slide really gets to the core of it, a huge difference from criminal law. See, in a civil case, it's a claimant versus a defendant, not the state prosecuting someone. The whole point isn't to punish, it's to find a remedy, which usually means money, right? That's why the standard of proof is what we call the balance of probabilities. The claimant just has to show their side of the story is more likely true than not. It's a lower bar, and that makes perfect sense when you think about it. We're not talking about taking away someone's freedom here. We're trying to find a fair solution to a private dispute. So that leads us to a really important question. If you've got one of these everyday disputes, where do you actually start? Where's your first stop in the legal system? Well, for the huge majority of civil claims in England and Wales, the journey starts right here, in the county court. I'm not kidding when I say this court is the workhorse of the civil system. It's built to handle an enormous volume and variety of cases, and to do it efficiently. Now, to manage this massive caseload, the county court cleverly sorts claims into one of three tracks. A great way to think about this is like lanes on a motorway, right? Each one has its own rules and its own speed. The small claims track, that's your inside lane for smaller, simpler disputes, and it's way less formal. Then you have the fast track, the middle lane for those mid-range claims with a much more structured and quicker timetable. And finally, you've got the multi-track. That's the fast lane for the big money cases or the really complex ones that need some serious hands-on management from the court. So who's in the driver's seat on these tracks? Well, you're mainly going to come across two types of judges. District judges handled the real bulk of the cases, all the small claims and a lot of the fast track stuff. For the more complicated or higher value cases, you'll find yourself in front of a circuit judge who's a bit more senior. And hey, here's a really practical tip for you. Getting the form of address right is a small detail, but it matters. It's sir or madam for a district judge, and your honor for a circuit judge. You'll want to remember that. Okay, let's switch gears for a minute. We're going to talk about a court that most people, probably you included, only ever associate with criminal law. But as you're about to see, the magistrate's court actually has a very specific and pretty important role to play in the civil world too. But here's the key thing to remember. Its civil work is very specific. We're not talking about contract disputes or personal injury claims here. No. This is all about administrative stuff and enforcement. So think about things like applying for a license to sell alcohol at a pub, or when the local council needs a court order because someone hasn't paid their council tax. These are definitely civil matters, but they fall into this very particular slice of the magistrate's court's jurisdiction. And what's really fascinating here is who makes these decisions. It's usually not a professional full-time judge. It's lay magistrates. You might have heard them called justices of the peace. These are volunteers, people from the local community, who bring their real-world experience to the bench. And of course, they don't do it alone. They're guided on all the tricky points of law by a legally qualified advisor. It's a perfect example of the justice system really being grounded in the community it serves. Okay, so a decision has been made in court. Great. But what if one side thinks the judge got it totally wrong? This is where the appeals system comes in. It provides a really structured way to challenge a judgment, but the path you take completely depends on where your case was heard in the first place. Right, so let's start with the most common scenario you'll come across. an appeal from a decision made in the county court. The single most important thing to remember here is that an appeal isn't always about going to a whole new court building. The general rule is simple. You just step up the judicial ladder. So, if a district judge heard your case, your first appeal is to a circuit judge. If a circuit judge made that initial decision, you go one step higher again, to a high court judge. See? It's a nice, clear, hierarchical progression. Step up, step up. But what about those very specific civil cases we talked about that are heard in the magistrate's court? Well, for those, the appeal route is completely different. With these cases, you appeal directly to a much more senior court, the high court. But, and this is crucial, this is not a do-over. You don't get to re-argue the entire case from scratch. No way. The appeal has to be based on a specific legal problem. For instance, an appeal by way of case stated is basically you saying, hey, the magistrate's got the law wrong. A judicial review is where you argue they acted outside their legal powers. Both are really technical legal challenges focused purely on law and procedure. Okay, let's make this real. Imagine your landlord unfairly keeps your £1,500 deposit. The value, £1,500, puts it squarely in the county court's small claims track. It would almost certainly be heard by a district judge. So, if you disagree with that judge's decision, where does your appeal go? You got it? It follows the rule we just learned. You go to the next judge up the ladder, which is a circuit judge. All right, let's take a bigger case. A business dispute, say over faulty machinery, and the claim is for £22,000. This value puts it right in the fast track. Now, because of the value, it might have been heard by a circuit judge right from the start. So if that's the case, where does the appeal go? Think about it. One level up, right? To a high court judge. You see how these examples just perfectly illustrate the logic of those appeal routes? All right, you have been taking in a lot of information. So let's put it to the test, just to see if everything has clicked into place for you. You ready? Let's do this. Here's question 1. Okay, so a claimant wants to start a personal injury claim, and it's valued at £45,000. Where should that case be started? I'll give you a second. The correct answer is the county court. The key rule you have to remember is that personal injury claims must be started in the county court unless their value is £50,000 or more. That's a specific rule just for PI cases. And for question 2, a small claims case was decided by a district judge. Where would the first appeal normally go? Take a moment. And the answer is a circuit judge. It comes back to that simple rule, doesn't it? The appeal goes to the next level up in the judicial hierarchy. A district judge is junior to a circuit judge. Simple as that. Excellent work. Okay, let's bring it all home now. We're going to wrap this up by summarizing the must-know points and, just as importantly, the common traps that trip students up so you can sidestep them in your exam. Okay, here is your revision checklist. Point 1, civil law is about disputes between individuals and finding a remedy. Point 2, the county court is the main starting point, and it uses that 3-track system, small claims, fast track, multi-track. Point 3, the magistrate's courts, a very, very limited civil role, mostly licensing and enforcement. And point 4, appeals, they generally step up to the next most senior judge. And finally, please avoid these common mistakes. Don't confuse civil and criminal jurisdiction or their standards of proof. You have to know the monetary values for the different tracks. Remember that appeals are often to the next judge, which isn't always the same as the next court. And don't overestimate what the magistrate's court does in civil cases. It's very limited. Nailing these distinctions is where you'll pick up those valuable marks. Now that you know how lower civil courts work and where appeals go, our next New to Law breakdown will take a look at the higher courts and how they shape the law. Thank you for joining another New to Law breakdown. Good luck with your exam prep and see you next time.